Welcome, everybody. We are live with another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge about an area of law that we practice in. I'm Senior Staff Attorney Susan Ingalls, here with our producer, Kenneth Elliott. And today we have a special guest, the student loan lawyer, Joshua Cohen. The pause in student loan payments is about to come to an end soon. And there are things you need to know, and Josh will be filling us in on deadlines, the latest in student loan repayment plans, and much more. But before we get started, we do want you, as always, to know that this is not legal advice. It's just general information for the public. If you need the help of a lawyer, you can call our intake line here at South Carolina Legal Services or apply online. And we'll provide that information at the end of today's presentation, and we'll also provide information, contact information for Joshua Cohen as well. Also, as a reminder, all of our episodes are posted by producer Kenneth Elliott to our Level Up Law playlist on our YouTube channel. So if you want to get a quick review, you can find it there. So for today, Josh can answer general questions at the conclusion of the presentation if time allows. So put any questions you have in the question box. If you have any technical difficulties, you can communicate with producer Kenneth Elliott in the chat. So also one quick reminder to be sure to check out our other social media besides YouTube. Like, subscribe, and get all that up-to-date information. We'll give you that information at the conclusion of today's presentation as well. I do want to ask you to scan this QR code. If you've got a topic to suggest, something you'd like to hear about, we've got so many, we've got well over 100 episodes of Level Up Law, but there is still a lot of information for us to provide to you. So scan that QR code and send your thoughts on what might be a good episode for us. Give it just a minute. And then let's go back, and this other QR code is to sign up for our newsletter. So you can scan that as well. If you'd like to be on our newsletter list, which is a great place to be. And at this time, I am going to turn the presentation over to Joshua Cohen, the student loan lawyer. Josh, thanks so much for being with us today. If you'll just go ahead and share your screen, we'll get started. Welcome.
Okay. Well, thank you for having me. And yes, you're right. The student loan pause will be stopping eventually. And technically it stops at either 60 days after the Supreme Court makes the decision on the Biden loan forgiveness lawsuit, or 60 days after June 30th. Since most Supreme Court decisions come out in June, I think we're safe in saying that August is when all of this will end. Some people have been asking me, well, how do we know that there won't be yet another pause? There can't be another pause because President Biden has said that the pandemic is over as far as emergency powers go, and the pause was under those emergency powers. So since those are gone, the pause will definitely be ending this summer. So don't get your hopes up for something else or some other kind of magic as far as a pause goes. Regardless of the Supreme Court decision, there are other avenues the Department of Education has researched that they're thinking about if the Supreme Court says no, but that's not something I can really discuss at this stage because we just don't know if we need to. What I do want to talk about, however, are updates that are important for anybody that has student loans or anybody that knows somebody with student loans. And I've got 6 things I want to touch upon here. We're going to start by talking about the IDR account adjustment, and that is income-driven repayment account adjustment. This is huge, and some deadlines have moved on this one. I want to talk about PSLF, public service loan forgiveness, both as it relates to the IDR account adjustment and changes coming starting July 1st. And then I want to talk about Fresh Start, which is a really neat program going on right now that will be going on for a little bit through June of 2024. It's a third option of getting out of default. I want to talk about the bankruptcy discharge. There's actually a change going on right now that can help some of you. And last, it looks like I've got two number 5s here, both total and permanent disability changes and borrower defense to repayment changes. We can call them both number 5 because they're both administrative discharge changes. So that's okay. They can share the 5th spot. So when we talk about income-driven repayment, many people are frustrated by it because they don't understand that even though you're not paying down the loan, it doesn't matter. These all come with forgiveness after 20 to 25 years, depending on which plan you're on. Income contingent repayment, the first one there, and IBR, income-based repayment, they all come with the 25-year forgiveness. If we look at pay as you earn, and new IBR, they come with a 20-year forgiveness. And then there's repay, which has got a combination. Repay is revised pay as you earn. If none of your loans are for graduate level studies, you get forgiveness after 20 years. But if a single loan is for graduate level studies, a master's or a PhD or some kind of advanced program, then it is a 25-year forgiveness. Now, if you switch, which you're allowed to do, if maybe you switch from income-based repayment to repay, the issue is going to be, do you have any graduate level loans? If you don't, then you get the 20 years under repay. If you do, then you'll get the 25-year under repay. The difference between these programs is not just the forgiveness, it's the formula. And I'm not going to get into the weeds on it, but I'm going to say that income contingent repayment is often the most expensive of these programs. Income-based repayment is right in the middle. It uses a 15% formula. Pay, new IBR, and repay all use a 10% formula. And while I'm here, let me also tell you about something you might have read about almost a month ago. There is a revision coming to repay, which will change the formula and the forgiveness under repay. And it's a formula that will be even cheaper than all of those that exist, regardless of whether you have graduate or undergraduate loans. But the forgiveness will change if you only have undergraduate level loans, to the point that if you originated $12,000 or less, you will get forgiveness after just 10 years. And for every $1,000 above that 12, you will just need to pay for an additional year. So at 13,000 origination, it's 11 years. At 14,000, it's 12 years. The maximum is still 20 years for undergraduate loans. If you have a graduate level, you're still at a 25-year plan. But again, this revision will be cheaper payments. We are hoping that comes online in September. It may be delayed till January. It's going through what's called negotiated rulemaking, where everyone gets to say their piece, and then we'll see the final revision. So I don't get into the weeds on that one because we don't know what it's really going to look like. But it will have the effect of cheaper payments and potential quicker forgiveness for undergraduate loans. So let's talk about this income-driven repayment adjustment. Now, basically, the Department of Education admitted that servicers weren't acting in a way that they agreed with. And many of you are familiar with this, where you called your servicer and said, I can't afford my payment. What can I do? And they immediately said, take a forbearance or take a deferment. And they didn't tell you about income-driven repayment, or they didn't tell you everything you needed to know to make an informed decision. Well, if you were on a forbearance or a deferment, you were not getting time towards the income-driven repayment forgiveness, the 20 or 25 years I just spoke about. So the Department of Education is doing a one-time income-driven repayment adjustment where for direct loans only, those being loans that were originated by the Department of Education, if you have those, they will do a one-time recount and give you credit for any payment you've made, regardless of the payment plan, even if it wasn't an IDR. They will give you credit for your forbearance time if you've either had a 12-month consecutive forbearance or you have at least 36 months of cumulative forbearance time, but not bankruptcy forbearance. That doesn't count. If you've got at least 36 months of cumulative or you've had a 1-year forbearance, you will get credit for all of the forbearance time. There will be a way to petition if you don't fit either one of these. You will also get credit for any deferments you had prior to 2013, so long as it wasn't an in-school deferment. The exception, which I didn't have on the slide, is any military deferment time, no matter when it was, that will count. Also, economic hardship deferments will count even if after 2013. So you will get credit for any payment you've made, all those forbearance time, the deferment time before 2013. You don't get credit for any time in default or bankruptcy. This is huge, okay? Essentially, it means if you've been out of school since 2003 for undergraduates or 1997 for graduates, graduate level, you probably have enough time accumulated that you will get immediate forgiveness when they do the recount. If you don't have all of the time you need, you simply need to remain in an income-driven repayment plan for the remainder. So if you get 22 years of credit, you'll only need to be in an income-driven payment plan for 3 more years. One advantage of consolidating, of putting all of your loans together, is they will give you credit back from your oldest loan. So if you've got some loans from the 90s and some loans from the 2000s, those newer loans will get credit with the older ones, okay? So another very important detail. Some of you may have really old loans from either the FFEL, or you may even have a Perkins loan, which is a loan originated by your school and administered through your school. FFEL loans are simply loans that were not originated by the Department of Education. You got them from a bank, you got them from a guarantee agency, you got them from a credit union. Sallie Mae is one example that many people are aware of. Sallie Mae does private and federal. Okay, and the best place to go to find out about this is at studentaid.gov. There's a slide at the end that has that there. Don't worry if you forget it. But if you have one of these FFEL or Perkins, if you consolidate before the end of the year, you will get time prior to the consolidation. They'll go back to the oldest loan. And again, you will get credit for your payments, for forbearance, for deferments, and you may be much closer to forgiveness than you ever thought was possible. This is awesome. Also, any forgiveness that you get before the end of 2025 is tax-free. So anyone who gets immediate forgiveness, tax-free. Isn't that awesome? On a federal level, it's tax-free. Again, if you don't have the 20 or 25 years you still get all the past credit and you'll be closer to forgiveness. You must enroll in an IDR plan to achieve forgiveness in the future. Parent Plus loans, if you have loans that you took out for your kids, then you'll need to consolidate it to direct loans, and then you can have income contingent repayment, which does qualify for forgiveness. All right, that was a mouthful, and that was the biggest plan to talk about. The next thing I want to talk about is public service loan forgiveness, PSLF. The IDR account adjustment will apply to PSLF. So if you had an FFEL loan, which doesn't qualify for PSLF, and you bring it over to the Department of Ed through direct loans, you will get credit. And as long as you were working during those times that you get credit for, whether forbearance or payment, then they will count towards public service loan forgiveness, which requires any qualifying employment after October of 2007. So if you've got 10 years of work for a qualifying employer since October of 07, and you get 10 years of credit for any payment made or those forbearance or deferments, even if it's an FFEL, then you may achieve forgiveness immediately. Okay, again, default time doesn't count, bankruptcy time doesn't count. But that's public service loan forgiveness will get credit with the income-driven repayment adjustment. Other important changes coming for public service loan forgiveness. This becomes effective July 1st. And actually, this is active right. This first bullet is active right now. You must be employed when you receive for the forgiveness. You must be employed by a qualifying employer. If you retire, you won't get the forgiveness. You need to get the forgiveness before you quit your job. Okay. An important change that's coming after July 1st is right now, it's not a matter of working 30 hours a week or more. It's a matter of, does HR qualify you as or consider you full-time or part-time? Part-time won't get the credit. After July 1st, it doesn't matter what HR designates you as long as you do 30 hours a week or more. If you're an adjunct professor, normally they only give you credit for the hours you teach. They don't give you credit for your office hours or things like that because they don't really know. Now adjuncts receive a 3.35 adjustment for each hour. So if HR says they teach 9 credits, you get those 9 credits times 3.35. That puts you over the 30 hours. Adjuncts will have an easier time qualifying. The second one here, the credit for contractors that by law can't be employed by qualifying employer. I don't know if that's a South Carolina issue, so I'm going to skip it. But if you do think it's an issue, my contact information is at the end. You're welcome to reach out to me. The other huge one here is the ability to make up payments. And this is really going to be an issue for the folks that filed in bankruptcy because bankruptcy time doesn't count. Okay, you will be able to make up the payments that weren't made during the bankruptcy or that were only half made, depending on what your bankruptcy worked. You'll be able to make up those times, so you may be able to still get forgiveness quicker than waiting for the time you missed. So that's public service loan forgiveness in a nutshell. Let's talk about Fresh Start. Fresh Start is for any federal student loan that's in default. Normally, the 2 ways to get out of default is through either consolidation or something called rehabilitation. I'm not going to discuss it because we have Fresh Start, which is valid now through June of 2024. And basically, you pick up the phone, you call the people that hold your loan, your federal loan, whether it's ECMC holds a lot of FFEL loans, or it's the Department of Education if you have a direct loan, and you have a 5-minute phone call. You say, I would like Fresh Start, and you agree to enroll in any income-driven repayment plan. They'll ask for your income information over the phone, 5-minute phone call, boom, that's it. Within 30 days, your loan will be out of default, and through August, you'll enjoy the pause. If it's an FFEL, you might still have to make payments, but it'll be under your income-driven repayment. Everybody starts paying in August, September. The default notation is removed from both the federal database of delinquent federal debts and from your credit report. You will be eligible for student aid if you're going back to school. There are no collection efforts until July of 2024. So you've got a little bit of time to decide what works best. If you're going to have a change in your income, decide when you want to sign up for income-driven repayment plan. But this is a huge deal. You're out of default in 5 minutes. If you're in a bankruptcy, there may be a little bit of an entanglement. Contact me, and I'll explain that, or I can work with your bankruptcy attorney. If you're not in bankruptcy, this is very easy. Pick up the phone. I want Fresh Start. Here's what my income is. Here's my family size. That's it. This is a one-time deal. And again, if you have a direct loan, you're going to get the income-driven repayment adjustment as well, and you will continue to accrue time once you're out of default. So this is a huge, huge deal. Bankruptcy discharge. Now, I know we've all read the internet where they say you can't get your federal loans discharged. First of all, that's incorrect. It is very difficult to get them discharged, but not impossible. Well, now the Department of Justice is working with the Department of Education, and if your loan is held by the Department of Education, then it is possible to have more relaxed standards to have your loan discharged in bankruptcy. First of all, this is only for newer bankruptcies. If your bankruptcy was open and active as of November 17, 2022, or newer, you can use this. If you filed a bankruptcy years ago and it was closed as of November 16, 2022, you cannot reopen and use what I'm talking about. Maybe you can file a new one, contact your bankruptcy attorney. Okay, IDR, income-driven repayment plan, not a factor anymore. I used to have a problem with people that had a $5 payment and how I'd make an argument. That's not an issue anymore. Instead, they are going to look at your income and expenses and compare it to what the standard plan would be. So what would it take to pay off your loan in 10 years, or if it's a consolidation, up to 30 years? Okay, that's what they compare it to. They do not use income-driven repayment plans. Other factors they're looking at is the debtor's age. Are you 65 or older? The age of the loans. Are the loans 10 years or older? And they mean you have been out of school. Oh, I'm sorry. You have been out of school for 10 years or more. Now, maybe you have a mix. Some of your loans are from undergrad and they're over 10 years, but you have graduate loans which aren't quite 10 years. You might still be able to do it all together. There are some nuances. We can talk to your bankruptcy attorney about that. If you have a disability, even if you're not eligible for the total and permanent disability discharge, it is a factor here. If it gets in the way of your employment, it's not that you can't work, but your employment is limited because of your disability. That's a factor. Your unemployment history is a factor. Your ability to continue making payments in the future is a factor. Other things they look at is the history of the loan. Have you ever enrolled in an income-driven repayment plan? Have you ever consolidated? Have you ever done a forbearance or a deferment? Have you had communications with Department of Ed or your servicer? Have you hired someone to assist you through the student loan process? And by the way, it means if you're talking to an attorney about your student loans, that's a checkbox and that helps you get it discharged. So again, this is much, much easier. We don't know how long this is going to be in play, so I encourage you to rush to your bankruptcy attorney and ask. If your bankruptcy attorney is scratching their head saying, I'm not sure, they can contact me. I will help them. Okay. The Department of Justice wants an 80% success rate. Wouldn't you like to be one of those 80%? This is awesome. Okay. Let's talk about the administrative changes that are coming as of July 1st, 2023. One of them is the TPD, total and permanent disability discharge. They are relaxing the standards. If you're a veteran and you're 100% disabled from a service-related incident, that's the same. If you're on Social Security disability, starting July 1st, you only need a 3-year review period on your benefit period query, your BPQI. Right now, it requires 5 years. As of July 1st, they go down to 3 years. You can get that from your Social Security office. Or if you've been on Social Security for 5 years at least, just send proof of that and your loan will be discharged. Or if you've aged out of Social Security disability, but you used to be on disability, if you can prove that when you were on it, you were either on it for 5 years or you had a 3-year review period, you just send that in with the application, boom, your loan is discharged. If you don't have either of the above, the veterans or disability, then you have a doctor certify it. And up until July 1st, you can only have an MD or a DO sign off on it. But starting July 1st, your nurse practitioner can sign it, your physician assistant can sign it, and your psychologist can assign it. So if you've got a mental condition that is getting in the way of your work, maybe your psychologist can sign this as of July 1st, and your loan is gone. The other thing they got rid of, which is huge, is there's no more income monitoring. They used to monitor your income for 3 years, and if you worked part-time or more and you made a certain amount of money, your loan would come back. That is gone as of July 1st. It means once your loan is discharged, tax-free, it's gone. I caution you about going back to school and getting more loans. You will sign an agreement that your disability won't get in the way. But if you're done and you have this disability that can qualify, let's do it. Let's get rid of that loan, tax-free. All right, and the other one I want to discuss real quick is the borrower defense to repayment. Okay, this is if you believe your school defrauded you or they gave you some kind of material misrepresentation that had you known, you would not have gone to that school and you would not have the loans that you have. This is more common among for-profit schools. I'm not dropping any names. There are some nonprofits where an issue has happened. Okay. But as of July 1st, the new changes will apply to anyone that applies after July 1st, or if you have an application, if you've already applied and they haven't made a ruling on it, then you will get the new standards. You will get 100% relief. There is no partial. If you demonstrate that you have a fraud or something to that and the Department of Education agrees, you get rid of 100% of the loan for that school. If you've gone to different schools, you'll have to apply for each of those schools if you have an issue. What's also new is the ability to create a group process. So this can start from the Department of Ed or a legal aid organization. So if you're aware that your school did something, you can go to local legal aid and say, look, it's not just me, I've got friends. And together, legal aid can petition the Department of Ed and say, look, we've got a local school or we have a bunch of local students and here's the issue. They can open it up as a group. And what this does is it makes it easier for people to apply to the point that I'll give you instances down with these 4 schools that once the school has a group process, when any person that went to one of those schools applies, it's almost an automatic discharge. And they've opened it up for ITT Tech. If you attended at any time between 2/5 and 2/16 when they closed, if you apply, you'll get your loan discharge. Corinthian, those were the big things that happened back in 2009 through 13. Maranello Beauty School or Westwood School of Photography. If you went to those schools through those dates, then they already have the established issues. You'll get your loan discharge. So by starting a group, you may open it up to another school. You could also work through the state attorney general's office. These are really the huge things. And what's also important is under the new regs, it doesn't matter when your loan was originated. These regs, this standards that they're using will apply to any loan at any date. So this is just, it's huge. Again, if you have questions, you're going to see my information on the resource slide. Okay, let's just go through acronyms just very quickly. And if you have questions, now's a good time to get them lined up. So BDTR is borrower defense to repayment. That's the slide I just talked about. Where if there was fraud or something like that. Direct loans are loans that are originated by the Department of Education. Compare those to an FFEL, Federal Family Education Loan. Sometimes they're called a commercial loan. These are loans that were originated by anyone other than the Department of Education. Again, could be your local bank, could have been Bank of America or Chase or Sallie Mae. Or there are some other lots of guarantee agencies like Vermont Student Assistance Corporation or Granite State or FIA, Pennsylvania Higher Ed, lots of different organizations. If it wasn't the Department of Ed, it's an FFEL. And again, these loans don't qualify for public service loan forgiveness. They don't qualify for the IDR account adjustment. You need to consolidate to direct loans. Direct loans is the only game in town now, so you can't screw it up. You go to studentaid.gov and you can get all your information there. IDR are the income-driven repayment plans. You've got income-based repayment, income contingent repayment, pay-as-you-earn, and revised pay-as-you-earn. PSLF is public service loan forgiveness, and TPD I mentioned on that slide is total and permanent disability. Just some very quick resources for you. Studentaid.gov is the federal loan data website. You can find lots of information, all of their press releases about income-driven repayment account adjustment you can find there. You can also get the history of your loan, all of your loan information. If you're not sure if you have direct or FFEL, go there, log in. It will tell you. Don't be afraid to log in. I have a lot of people that ask me, well, if I log in, aren't I waking up the bear and it's going to come after me now when I've been in default for so long? Absolutely not. Especially now, there's no collection activity anyway. So go there, get your student loan information. If you're working with an attorney, they're going to send you there because that's where they find all the information. Another great resource for you is Student Loan Borrower Assistance, which is through National Consumer Law Center out of Boston. They are a nonprofit. They have some great information about student loans. They also help translate what you might be reading on the Department of Education. If you have any questions for me, you can email me at my email address, or you want to talk, you can also book an appointment through my website. And that's pretty much all I have for you. I've just kind of run through it quicker than I might have expected. If we have questions, now's a great time to ask. I'm happy to answer any.
That's great, Josh. Thank you so much. That was a really great review of what's going on with student loans right now. We do have one question already, and actually this viewer actually missed the part about public student loan forgiveness and asked if you will please provide just a quick update of that one more time. And of course, just so you'll know, to our viewers, we will post the recording of this on our YouTube channel, so you can also look back on there. But Josh, if you don't mind running through that public student loan forgiveness one more time, that'd be awesome.
That's fine. Let me get back to that slide. Give me a second, please don't get dizzy. Okay, so there were two things that we discussed. First of all, the income-driven repayment account adjustment will apply to public service loan forgiveness. So if your loan doesn't qualify, if you have an FFEL, you have until December 31st, 2023 to consolidate to Department of Ed. You will then get the IDR account adjustment, which will count towards PSLF. So any payment made, any forbearances, deferments before 213, that will all count, as long as you also, in each month that counts, you also have worked for a qualifying employer. Qualifying employers are any government agency or a 501c3 nonprofit, or certain not-for-profits that are public service oriented, such as ambulance companies. And when I say government work, it's not a contractor. You can't be a contractor for the government. You must be on W-2 payroll for the government. And that could be federal, state, county, town, municipal, whatever it is. It doesn't matter what your job title is, as long as you are full-time before July 1st, 2023, and 30 hours a week after July 1st, 2023. Okay? So that's the income-driven repayment adjustment. And this, again, is the updates as of July 1st, 2023. Again, you must be 30 hours or more. It doesn't matter if you're full-time or part-time. You just have to have 30 hours on the clock. And you must be employed when you're seeking forgiveness. If you spent 10 years at the Red Cross, but you're no longer there, you're not going to get the forgiveness unless you are still working a qualifying job when you apply and are granted the forgiveness. If that means you need to get a job for the next 3 months just to get the forgiveness, then go do it. Again, adjuncts are getting a factor in there. And there's the ability to make up payments after July 1st, 2023. And you won't need that for the IDR account adjustment, but going forward, if for some reason you take a forbearance instead of making payment, you'll be able to make up those payments that you missed. So hopefully that addresses those questions for public service loan forgiveness.
I think so. And now we have another question, which is, if you have the public student loan forgiveness, should we start our repayment now?
Okay, if you're going to get public service loan forgiveness, that is irrelevant about making payments now. Because right now, again, in order to have PSLF, you must have a direct loan with the Department of Ed. If you have a direct loan with Department of Ed, you have the pandemic pause. No payments are required, but all of the time during the pandemic pause still counts towards public service loan forgiveness. So if you haven't made a payment since March of 2020, that's okay. You're going to get credit, and you will get credit through August when payments restart. So if you need to make payments now, no, you don't. Do you want to get set up for an income-driven repayment come August or September so that if you need more time, you'll qualify? Yes. Yes, you should.
Great. Good questions. Well, it looks like we don't have any other questions at the moment. If you want to go back to your last slide, Josh, and we'll make sure everybody gets those resources. And we really do appreciate you being with us today. That is great information, a lot going on in the world of student loans, and everybody does need to know about that. So I'm going to switch over for our viewers. Yes. And I just wanted to say, we've already looked at this QR code. Here's how you can connect with us, and we always like to end the show with this information. Again, our QR code to sign up for that newsletter is here, so you can go ahead and be scanning that. But we have all of our Level Up Law episodes posted on that playlist on our YouTube channel. And we definitely invite you to go there. But we have other resources and connections that we put out there for you on all these other social media platforms that we use. So you can find us there as well. Also, here's the information about how to apply for our free services. You can do it by telephone, or you can do it online. That's 24/7. If you're calling, our intake office is open Monday through Thursday from 9 to 6. So definitely check that out. I'm going to check one more time on our questions before we go, and then we can. I think that's all the questions. Josh, you covered everything so good, and it's a lot for everybody to take in. So it may be that folks will have questions after today. But at this time, I do want to thank you, Joshua Cohen, the student loan lawyer, for a great presentation, and really appreciate that. And I also want to thank our audience for joining us here each week on Level Up Law for whatever information we're providing for you. Or if you join us later on the replay on our YouTube channel, we always appreciate you checking it out. Now, if you found this presentation helpful, which I know you must have, I think we all did, and it's going to be helpful to you or even helpful to others that you may know, definitely go to our YouTube channel at SC Legal Services, as you can see here, and share the broadcast. We want as many people as possible to get this important student loan information. And while you're there, be sure to like and subscribe for more. And if you sign up for those notifications while you're there, you'll get a notification each week when we post a new episode. So definitely do that. And also be sure to tune in next week on Tuesday at noon for another episode of Level Up Law, when the subject is going to be rural broadband. How can we connect with our folks in the rural areas of South Carolina where it can be hard to get that badly needed Wi-Fi that seems like these days everything relies on, even with your student aid report that you get, that's an online situation. And I might ask you, Josh, if there is someone who needs to get their student loan information and they don't have the ability to do it online, and of course, yeah, we can all go to the library and hopefully access the internet there. Is there a way to get that just by requesting it in writing?
You can request it in writing. Also on the website is a toll-free number that you can call, and they'll mail it to you. It can take about 3 weeks to get it that way, but they can do it.
Okay, perfect. Well, that's great information. Well, listen, thanks everybody again for tuning in today on Level Up Law. Thanks again to the student loan lawyer, Joshua Cohen, who is a wealth of information. I highly recommend his all of his information on student loans. He does a great job. So thanks, Josh, and thanks everyone. That concludes today's webinar. Thanks for tuning in, everybody.